I'm absolutely delighted to be back. Feels like a new school year. Back with Stewarts Soundbites, and I'm really, really pleased to introduce you to Chloe Birch today, who's a barrister at Mountford Chambers. And Chloe has a really busy criminal practice and do a lot of criminal defence work. And now, how we're going to squash this into 15 minutes, I don't know, Chloe, but we're going to try, because we're talking today a little bit about kind of traumatic brain injury and how that is dealt with, how it's managed, how it's recognised in the criminal justice system. And we talked on the phone about this for about an hour and barely scratched the surface. So we're going to try and do our best to be as succinct as we can. But thank you all so much for joining us, whether you're live or watching it as a recording. Really lovely to be back. So Chloe, thank you so much for being here and kicking us back off.
Thank you so much for having me. I'm delighted to be the first one back in the new series. It's a pleasure to be here. Thank you.
Oh, no, thank you. So I think we should just dive in because we've got so much to talk about. And I suppose our starting point has got to be from your experience and from kind of working in the sphere that you do. Maybe you could just give us a little bit of an introduction, Chloe, in terms of all the meaty kind of statistics and information about kind of the number of people and the type of people who have traumatic brain injuries and go through the criminal justice system. Is it something that's more common than we would be led to believe?
I think that's absolutely right. And I think it's quite surprising when you dig down into some of those statistics. So the adult male prisoner population, 60% of them have had some sort of traumatic brain injury, whether that be through road traffic accident or assault, violence, operation, surgery, those sorts of things. 60% of the prisoner population. Well, if you compare that to the national population of the general population, 8% of the general population have a brain injury, compared to 60% within the prisoner population. So you can see that that's overwhelmingly disproportionate compared to the number of people in prison. In the women's prison, Drake Hall, about 64% of those women were either screened or reported as having some sort of history indicative of brain injury. And for them, for women in particular, about 62% of women with a brain injury have that as a result of domestic violence. And so you can see that the statistics compared to what you might consider as the general population are staggering.
It's scary, actually. The figures are, it's more than I would ever have anticipated, Chloe. And I suppose the main question, how well equipped are we? And we're talking about the UK, I should be clear. How well equipped really are we in the criminal justice system to handle these people? Not just, and I suppose we're talking, aren't we, about from arrest, from the beginning right through, we're not just talking about prisoners, we're talking about kind of a really broad spectrum of people. So how well equipped are we to deal with those people that do have these injuries?
Absolutely, and it's not just adults. So you might think that relates to over 18s, but of course the criminal justice system deals with youth offenders as well. Something I do a lot of work with in terms of youth justice, and 30% of youth offenders have had some sort of brain injury as well. And the scientists say that number is actually quite low because of the length of time they've been alive to have a history of some sort of brain injury. But if you think about 30% in terms of youth offenders, again, compared to that 8% general population figure, that's a huge amount.
Yeah.
And in reality, actually, we're not very well equipped at all. Brain injury is something that, might be considered quite a hot topic at the moment. But despite that, sort of the first reports, the first investigations into the prisoner population really started to take place in 2019 when some of these statistics were first collated, which is really very, very recent history.
Wild, yeah.
Yeah. And so if you think about how dynamic the criminal justice system is, these aren't people who are coming to court or coming to the police station having planned and prepared for it. They're people who are arrested there and then at the scene, or who have been arrested and remanded overnight at a police station and appear at the magistrate's court the next morning or the next day after that. So these aren't people coming to court prepared with bundles and documents and reports, like perhaps they might be in other areas of law. They are often meeting a lawyer for the first time in a police station consultation room, or meeting me and one of my colleagues as an advocate at court, either in the cells or up at the magistrates' court for the first appearance. And really, we're the screening process. The advocates at court, the lawyers at the police station, we are the screening process. There aren't mandatory screening processes, and unless a person is visibly unwell, I should say. And we're well versed. We're not medical practitioners, but we're well versed in things like paranoid schizophrenia, bipolar, personality disorders, because we deal with them so frequently.
Yeah.
And that's unfortunate, but it's something we're quite well versed at recognising. And there are mental health teams occasionally at some magistrates' courts, not often, but there are some, and we can sort of alert them and ask for assessments there and then. But with brain injury, it's such a hidden disability, it's such a hidden manifestation on people that you might not be able to recognise it. If you're not aware of it, we're simply not as well versed as we might be in other areas. And so we become the screening process, which is why it's so important for practitioners to be aware of brain injury, to think about how it might manifest itself, and the things to look for, in the same way that we know how to look for mental health conditions and physical health conditions, and know what to do when we do see it. And because, as I say, the first time you might meet someone might be in the cells for a first appearance, you're not equipped with medical documents, medical reports, or GP diagnoses and things like that. You've either got to rely on your own assessment and your own ability to ask questions of someone, but also that person to be able to tell you. And so often, as we know, one of the things about brain injuries is not being able to necessarily communicate, or not knowing how to communicate with someone. And so it is difficult, I think, at the moment to know that are we really recognising that 60% of our clients may well have a brain injury? I'm not sure.
Yeah, and of course the other aspect of it is a lot of people, we see it a lot in our area of work with brain injuries, don't have insight into their own kind of deficits, and that is almost impossible for you to pick up on something that's, really inconspicuous but might be fairly debilitating. So it's a huge ask, really, of lawyers to go in and to kind of use their experience. It's kind of worrying, isn't it, that that's the screening process, even though you're also, as you say, well used to some presentations. I wonder how we see these problems kind of play out. So I was thinking kind of practically, and as we mentioned, we're talking from a whole range here, aren't we, about kind of from arrest to sentencing to time in prison. How do we see these problems kind of play out in real time?
So I think some of the things that are happening are, for example, the time that you have with a client. Perhaps some of those things that we know about brain injury in terms of communication delays, so delay in being able to put things into words, or cognitive processing, being able to understand what's being said. So in a very short time frame, as a criminal lawyer, you have to be able to explain the evidence to your client, make sure they understand the case against them, and that they're able to give you instructions back. So are they able to say, well, no, hang on, I wasn't the person in the red t-shirt, or I wasn't there, or whatever it is that they have to be able to give you as instructions? Are they be able to understand the evidence and then give you instructions back in a very quick time frame, often very little time at all in those first hearings or in that police consultation? So that's the first thing that we've got to deal with in terms of difficulties. And also I think that knocks on in terms of effective participation in any court hearing. So court hearings happen so quickly for the lawyers, for the magistrates, for the judges who are doing it day in, day out. We know what we're talking about in terms of, for example, setting stage dates for a trial. If you haven't done that before, if you're not used to that, or if you're not processing as quickly as everybody else in the room, then that prevents you from participating effectively in your trial, in your case, and understanding. there's a court in New Zealand, so they're really switched on to this in New Zealand, and they're creating pioneering brain injury screening programs that are just incredible. And they've created a specialist youth court there for the ages of 18 to 25, which is sort of that covering time between being a child and being an adult. And the judge that's setting that up, he said, if you had someone appearing in your court that couldn't speak English, the absolute first thing you would do is get an interpreter. Everybody would know that that's what you would need to be fair. It's exactly the same matter of fairness for someone who has a brain injury or who has a neurodisability that prevents them from understanding in the same way you wouldn't understand a language, that they need some sort of adaptation to be able to translate, to be able to follow. And I think that's a really sort of tangible example of how you can think that somebody might not be following every word, every phrase to know what's going on, to be able to participate in their own case. And so that's something I think in terms of communication that is really difficult. And also in terms of funding, you know, to get expert reports, to have an expert give an assessment, because we're not medical experts in any sense. And whilst we might have professional concerns and judgment calls to make about whether our clients can participate, we can't give expert evidence on our own. And of course, we'll need neuropsychologists, speech and language therapists, intermediaries to assess our clients. All of that very often requires funding from the legal aid agency and applications to adjourn to be able to do all of that, which of course causes some delay and can be a little bit of a battle to make sure that you get the time to make sure you've crossed those T's and dotted those I's, particularly with brain injury where it might not be so visible, to be able to persuade a court to give you a little more time to explore all of that is really important.
So that is really up to the lawyers, isn't it, to flag that and to say this is required in this case. And that goes back to what we were saying about you kind of having that intuition and recognising something. And we're talking about brain injury, which is, you know, presents in, you know, just millions of different ways for different people. It's so hard. And I guess during, you know, what I've been thinking about and what we talked about a little bit before was kind of staff in the criminal justice system. And, you know, I suppose that kind of leads me on to my next question, which is basically what needs to happen? You know, how do we address this, and how do we, you know, where does the improvement come in? What are we aiming for?
So I think there have been some really good improvements, the more that brain injury is talked about and explored. So for example, we now have a specialist sentencing guideline for defendants who have, it's called mental disorders, and that covers a very broad range of mental health conditions. But one of those which is explicitly referenced in that list is neurological conditions and brain injury, acquired brain injury. And that you can use that to explain to a judge that culpability might be reduced as a direct result of a brain injury. And so that can help in terms of mitigation for bringing a sentence down, for example, and it legitimises those concerns because they're actually in the guideline. Similarly, the charity Headway, they've been creating work, guidance for probation services so that brain injury would be included in pre-sentence reports like any other disability would. And again, it just legitimises that in front of a tribunal who may not know much about brain injury or may not know how to take that into account. So we are getting there, but that's, you know, that's at sentence, that's later down the line, and we need to be doing more to either stop people being prosecuted in the first place or to allow and make sure that they have the ability to effectively participate in a trial.
Yeah, and it's a lot of pressure on staff as well, isn't it? From everything from, you know, staff of the court, probation officers, you know, prison officers, you know, because they're not necessarily going to be trained in, you know, so that's kind of maybe something else. I mean, it's just so interesting. There's so much. The problem with it is, and the problem with everything in our world and our legal world is, you know, funding to kind of institute this change. But as you say, kind of talking about it is a good starting point, people kind of understanding it. And I know we're out of time. But I do want to ask you one more question, because I'm such a huge fan of a kind of a a top tip. So I'm going to be really cheeky and ask you, do you have any advice for people working with those who've sustained brain injuries, or family members, or because we do see it where somebody sustains a brain injury and then there are problems, and those individuals end up in the criminal justice system. Do you have any kind of takeaway for those people?
I think the most important thing is awareness. Make sure that whoever it is that's representing you knows. If you've got medical records, if you've got a letter from your GP or from your consultant, from a neuropsychologist, a Headway charity that's looking after you, bring the letters, come as a family member to court, and make sure you say, do you know about the brain injury? Has he told you about this? Or could you see that he had some fatigue when he wasn't able to explain? Come and make sure that you're equipped with all of that information if you can, because if we're equipped with it, then we can start persuading judges to adjourn for reports, to look at experts, to write reps to the Crown and say, look, what are you doing? This isn't in the public interest. So if you can equip us with the information, then we can start dealing with it, as best as we possibly can. I know that's not always as simple as it sounds, but I think the more information we're given and the less we have to try and track down ourselves from our own instincts, the better we are equipped to work with it in the courtroom.
Yeah. That's so useful. Quite a real practical kind of takeaway. Thank you. The only thing the lawyer in me, the personal injury lawyer in me, wants to say that if there's a litigation, ask your solicitor before you hand me documents. But that's me.
Do that.
Listen, Chloe, thank you so much. It's been such a pleasure to have you. As always, I've gone over time. I'm so sorry. I'm going to get told off again. But if there are any questions, I know we don't have time to deal with them right now, but we're going to, everyone will have my contact details. You can send stuff to me and we'll make Chloe's details available. She agreed, so she can't go back on it now. We're going to put our details on the recording. So any questions at all, please give us a shout. And thank you so much for joining us. And we'll see you soon.
Thanks, Emma.
Thanks.